Have you ever wondered what your rights are as a tenant or a landlord when it comes to property maintenance? Well, whether you're dealing with a broken air conditioning, an unsafe stairwell, or even an unexpected pest infestation, understanding these rights are crucial. And that is what we're discussing today. Now I want to begin this video with a disclaimer. Several states have their own state statutes that govern rights and responsibilities of the landlord and the tenant. Here in Florida, it's called the Florida Landlord-Tenant Act. But in 1972, the federal government created the Uniform Residential Landlord-Tenant Act, or the URLTA. It was created in an effort to standardize each state's rules and regulations. Since its creation, 26 states have adopted it, so the rules in other states may have some slight differences. But rather than try to address each state specifically, I'll be using the Uniform Residential Landlord-Tenant Act as my reference for this video. With that disclaimer, as well as letting you know that I'm not an attorney, we're ready to get started. I'll start with some basic tenant rights and responsibilities. Number one, a tenant has a right to a habitable unit. A tenant has the right to live in a unit that meets basic safety, health, and structural standards. This is known as the implied warranty of habitability. If a property is deemed uninhabitable, for example, due to plumbing failure, no heat in the winter, or a severe mold issue, the tenant may have grounds to withhold rent or even terminate the lease. However, proper procedures must be followed. For example, in a court case, Gauld v. Ovid, the tenants left their rental unit immediately upon finding bed bugs, but had not given their landlord time to resolve the issue. And because they didn't give notice or allow the landlord time to make repairs, they were still held responsible for the entire amount of the rent owed. And this leads us to the tenant's duty to report issues. Tenants must notify landlords about problems that affect the property's habitability. The URLTA requires the tenants provide written notice. That is extremely important, written notice, especially when it's in some format that you can prove it was delivered. The written notice has to give the landlord a reasonable opportunity to address the concern. Now, if the tenant wants to remain in the unit and they've already notified the landlord, but the landlord is failing to respond, some states will allow for the repair and deduct situation. This is when the landlord fails to address a major issue after written notice was provided. Then the tenant can pay for the repairs themselves and deduct the cost from the rent. In situations when this is allowed, there's usually a cap of like 1 month's rent. But because this can be a touchy situation, tenants should always document their written requests to the landlord and keep receipts for any repairs that are performed. Because without proper documentation, especially for notification, the tenants may not be able to justify their actions. Now, in extreme cases, such as severe infestations, structural collapse, or unsafe utilities, tenants could argue for constructive eviction. This occurs when conditions are so poor that the tenant has no choice but to leave the property for their own health and safety. However, tenants still need to notify the landlord of the problem and give them a reasonable time frame to address the issue before terminating the lease. On the flip side, landlords also have some rights and responsibilities. The first one is maintaining common areas. This mainly pertains to if you have a building or if somewhere in the lease it says the landlord is maintaining the common areas. But landlords are responsible for ensuring that the common areas such as hallways, staircases, laundry rooms, playgrounds are safe, clean, and properly maintained. In a case Young v. Northington, a landlord was held liable after a tenant was injured in a common area due to unsafe conditions. And there's many other cases with very similar outcomes. The landlord also has the responsibility to perform timely repairs. Landlords must respond to maintenance requests promptly. Neglecting serious issues can result in constructive eviction claims, meaning the tenant may legally break the lease without financial penalty. However, it is important to note that addressing the issue timely may not always mean resolving it. Sometimes vendors are pushed out. A repair may need multiple stages in order to resolve it. Sometimes a repair is performed and believed to be complete only for it to fail again. For instance, a roof leak. If you call a roofer out and he says he addresses the issue, no one will know until it rains again whether or not it was truly resolved. So the main point here is that the landlord is demonstrating that progress is being made on the issue. Next is the landlord's responsibility to address health hazards. Lead-based paint, mold, or vermin infestations are all concerns that landlords must address. For instance, landlords are required by law to disclose the presence of lead paint and provide educational materials under the Residential Lead-Based Paint Hazard Reduction Act. With pest infestations, there can be some gray areas. So if the issue presents itself as soon as the tenant moves in, it's more likely to be the landlord's problem. If the issue develops months after the tenant moves in, then the problem was likely brought in by the tenant and no longer the landlord's responsibility. Sometimes a tenant's lifestyle can bring vermin into the house, but if it was a situation where there's fruit trees outside and there's a fruit bat in the attic, probably a landlord issue. If there are termites in the rafters, then probably a landlord issue. But if there's ants or roaches in the house and the house isn't being kept clean, then that is probably a tenant issue and the landlord would not be responsible for correcting that. Next, we're going to talk about preventing liability for criminal acts. This is another responsibility of the landlord. In some cases, landlords can be held responsible for criminal acts that are committed on or around the property. For example, if a landlord fails to provide adequate lighting or secure locks in common areas, or if a dangerous situation is brought to their attention and they do nothing about it, they could find themselves facing some liability for that situation. Some key legal cases to remember here are Harvey versus Photo Property Services. This is where a tenant claimed damages for furniture ruined by bed bugs, but the court ruled that while landlords must keep units clean and vermin-free, they aren't responsible for replacing tenants' property unless negligence is proven. Another one is Felice versus Wharf. Tenants claimed a flea infestation rendered their unit unlivable, but the court determined that since exterminators could not find any evidence of fleas, the tenants were not entitled to any additional rent deductions beyond the few that the landlord had already offered. Gress and Wetcher, in this case, the tenant sued the landlord for injuries sustained after slipping on ice caused by a leaking gutter. However, the court ruled that since the tenant was aware of the ice and had attempted to maintain it themselves, they failed to establish any negligence on the landlord's part. So this case shows the importance of clearly defining maintenance responsibilities in the lease agreement. To sum it up with some practical tips for both the landlord and the tenant, tenants should inspect the property before signing the lease. Familiarize yourself with the lease by reading it thoroughly before signing it. Document any maintenance issues upon move-in. Report maintenance issues in writing and keep a copy for your records. For landlords, perform regular property inspections and keep records of all maintenance. Next, you want to thoroughly address maintenance issues and processes in your lease. That way, everyone knows whose responsibility which maintenance issues are. You also want to establish a clear process for tenants to submit maintenance requests. You want to respond to maintenance issues promptly to avoid any disputes. Now, I mentioned the lease a few times, so I want to note that while there are laws, statutes, and prior court rulings to provide some guidance on these issues, do not overlook the importance of the lease. This is where it all begins. The lease should be very detailed when addressing these issues and who is responsible for what. That is why I believe step one is for landlords to make sure they are very thorough when crafting their leases, and tenants, make sure you read it very carefully before you sign. Just doing that will help both parties resolve many of these issues before they ever begin. Now, if you found this video helpful, don't forget to like, comment, and subscribe to stay informed, protected, and profitable. See you next time.